You know, for me, the Daniel Perry trial brought to light some kinks in the armor that is the Bill of Rights. The protections a defendant should have against a malicious prosecutor. A prosecutor that isn't prosecuting because he's going after a crime, but because he's going after an opportunity, a way to advance his own ends, the prosecutor's way to advance his own ends. And not for the sake of justice. It's the worst kind of prosecution. It's what the Bill of Rights, in theory, was meant to protect against. But we saw some kinks in that armor. One of them is, when does jeopardy attach? Does it attach when a person is, on in court with when the jury is sworn in? Is that when jeopardy attaches? Is it Downham versus United States that said that? Apparently, that's when jeopardy attaches. Why doesn't it attach when a person loses their liberty? Why doesn't it attach then? Obviously, circumstances can change this. If it's a felony indictment and there's good probable cause, how much time does the state have to bring a case? Like, if a defendant invokes his right to a speedy trial, what protections does a defendant have against a state that just wants to be malicious in the public eye as well? In a way of painting a person a certain way to where there's so much public scorn that this person can't even go outside for fear of their own safety, because in the public's eye, this person is guilty of a very heinous crime. Are they really guilty? What if they weren't guilty? Is there any protection to stop that? You would think that someone in power would never do something like that. But it really sucks when you're proven wrong and you do see it. And it's disturbing because it makes you wonder, well, I hope there's protections against that, because that would be bad. I'm starting to learn more and more that those protections don't seem to be enough, or not specific enough, or not written well enough, at least for the modern day and age. Or is that the way to think about it? I saw a defendant just put through the ringer. This defense attorney couldn't really, they tried to paint him in a good light, but the strategy at the time was say little and invoke your right to remain silent. But the prosecutor had a good strategy. You see, they had consulting firms and were releasing stuff to reporters to paint this guy in such a horrible light that any potential juror, maybe not any, but it's quite likely, more probable than not likely, that there would be someone on the jury that would be so prejudicial against the defendant that he may not get a fair trial. The crime in and of itself, it was framed in such a way that it made him look like a racist, when we know that he probably is not a racist. And even if he is, should even a racist be allowed to act in legitimate self-defense if that was the motivation for acting in self-defense? A lot of fundamental questions that we're coming back to. And that's why this case to me is so historically precedent setting, because it shows the most gapping, the most wide open gates of a defendant's rights against malicious prosecution. It is truly disturbing to see that those gaps are there, and they're not exactly being closed, and they can be exploited again at a later time in the near future or from a future prosecutor. You would hope that a case against a defendant is brought with evidence and legal merits, but if it isn't, what protections are there? And it seems like those protections are not doing their job well enough to keep an innocent person out of prison. That's the problem. And there needs to be a solution. There has to be a balance here. But it seems like the balance is teetered a little too far for making it easy to indict a person based off things that are not relevant to the crime alleged.